brought this suit has already expired. You may be seated. You don't have to stand up until I need you to start. Thank you, Kevin. And so that I'm clear with what has been offered, I found at least 3 issues in the complaint. The issue of the invasion of privacy, misappropriation of the identity, and false light, and 3 or 4, the intentional or negligent infliction of emotional distress. When I looked at the brief, everybody agrees that 1, 2, and 3 are governed by the 1-year statute of limitations, correct?
Yes, Your Honor.
I'm going from what I found in the brief. We also agree that the complaint has to state a cause of action or should we? I'm in agreement with myself on it, and I think with the case law that the negligent infliction of emotional distress has to be an action that at least has been stated clearly in the complaint, and that the plaintiff has advanced before the court evidence that will survive emotional dishonesty judgment, and there may be a claim that statute of limitation would be longer than the 1-year statute of limitation. In review, when I find a negligent infliction of emotional distress claim, either within the complaint other than by the statement, but not in anything produced by the plaintiff. So the court looks at it in terms of there being 3 issues with 1-year statute of limitation. In your briefs, the suit argues that the case argues that the suit was filed February the 9th in 2011. And the court takes judicial notice of the fact that it wasn't being filed. It was published February the 10th, 2009, in a disagreement regarding that. Then I read the brief, the plaintiff alleged that Ms. Cooper was contacted by the writer in January of 2009, the month before publication. Am I correct in that? Now, what was unclear to me was what happened in January 2009 and on what day it happened.
Your Honor, in January 2009, Ms. Stockton, through her brother and sister-in-law, contacted Ms. Cooper and provided her with a copy of
What do you mean? Through her brother and sister, how did she contact?
Ms. Stockton wrote Ms. Cooper a note and provided her with a copy of the
Then you didn't provide the court a copy of it, you know,
No, ma'am.
that I recall.
No, ma'am. I just referenced the fact that Ms. Stockton contacted her through the note.
Where's the note?
The note is in our possession.
But counsel, you're here to survive motion for summary judgment. What was the date of the note?
The date of the note was January 2000.
And what did the note say?
The note simply said, enclosed, and I referenced the note in the affidavit. There's nothing in the note that's not in the affidavit at all. And I spoke on that.
Yes, sir. That's the affidavit that you have exhibit B, or the second affidavit, because the A is the issue of limiting the damages. But we're not to the issue of damages. Right now, we're at the issue of whether you should be in school.
Your Honor, it's not, it was not referenced in the affidavit. It was referenced in our brief, and there's absolutely nothing in the note that is not referenced in the brief. She basically, she said that the character is based on her favorite maid. She said that was loosely based and inspired on a character of an individual named Dimitri. She did not tell Ms. Cooper that this book takes place in Jackson, Mississippi. She did not tell Ms. Cooper that this character that she blindly refers to her own skin color as that of a cockroach. She did not tell Ms. Cooper that the language that is used in the book, she did not say the book takes place in Jackson, Mississippi. It basically said, here's a copy of the book, my brother loves you, his children love you, thank you for taking care of them, and that's the extent of it. That was what was in the
Your client provided a copy of the book January 2009.
Yes, Your Honor.
Then, counsel, what's your argument that you could file a suit in 2011, almost a year past what would normally be considered the statute of limitation once you got a copy of the book?
Your Honor, in Mississippi, we've adopted the discovery rule for issues such as this. And
No, sir. You can't adopt it. I'm just saying. Tell me what would keep her from January, when she received a copy of the book, from filing an action within the year statute of limitation, and that would have been February 2010.
Yes, Your Honor. We submitted, it is the law in Mississippi, this discovery rule. Is it reasonable for someone not to file a claim within these 1 year statute of limitations? Is that reasonable? It's the Holland case. And
The statute, you're talking about the savings law, and it's really new or should have not.
yes, Your Honor. And that's in the Supreme Court said in the Holland case, the old Memphis professor, he was lost on summary judgment, said it was not filed within a year. They said, well, there are certain circumstances where it is a jury to determine did a person basically sit on their rights, or are there some facts that show, you know what, it's reasonable why this person waited more than a year. And that's what we argue, it is more than a year, but we claim that it's a jury question to determine were Ms. Cooper's actions reasonable. The fact that Catherine Stockett basically said there's nothing offensive in this book at all. She doesn't tell her anything other than, this is a great book, hope you enjoy it. And quite frankly, Ms. Cooper has other things going on in her life. And, reading a 450-page book is not really on the top of her priority list at that time.
Counsel, if the book was given to her January 2009, she was aware of what the book was about, correct?
Your Honor, all she was told was that
She didn't have to be told that she was reading the book. She had a copy of it.
she had a copy of the book, Your Honor, but she did not read the book. I mean, Ms. Cooper is not somebody who reads a lot of fiction.
I'm not counsel, but I believe that if I'd been told that I was in a book, I would be
What Ms. Stockett led her to believe, and what we think is reasonable for her to believe, was that
It's not just reasonable. The only issue reasonable is as to when she should have known, and the statute began to run.
yes,
When she should have known, not when she actually knew, but was she in a position to say it to the board, she received the book, it was available to her. For her to ignore it does not give her the benefit of your argument that there was some misrepresentation or something that was not disclosed.
well, just that Ms. Stockett's representation for this book is not about her. This book is not not about you. So we think it's a jury question. If she's given a book and the author says it's not about you, then there's really not a compelling reason, we feel, for someone to read a book when you're told it's not about you. The only thing this Statute made clear to her was that Rob and Carol Statute loved her very much.
And your argument is that the book was about.
And in fact, that what the Statute told her was not about her. But when you look at the similarities between Ablene in the book and Ablene in real life, there's no way the Statute just all of a sudden bring this up. She based it clearly on facts pertaining to Ms. Cooper sitting.
And no question, counsel, you can argue that to a jury. The first thing you must overcome is the timeliness of the suit. And you've not presented anything to this court to explain why anyone would receive a copy of the book in January of 2009, have it for an entire year, and not bring their action within the 1 year statute of limitation. She may very well be the carrier. All of that is good and fine, and both sides argued that throughout your briefs, but the issue is whether this court can proceed forward when there's a clear statute of limitation, and the court has found or concealed it. You've admitted it was given to her.
Yes, sir.
And she could have read it. But the fact that she didn't read it does not give her relief in the court.
We just start my perspective that that's it. Her actions being reasonable or not was a jury question. Or is it?
Yes, sir. Thank you.
Yes, sir.
Is there a response from the defendant?
I agree that with the court's rationale, she got the book, but she had not opportunity to read it. She can't sit on the rest and not read it. Counsel's description of the Heller case is way off base. The Heller was a matter in which there was a community issue, and there was a contradiction of ruling that was unavailable to him. The only publication was unavailable to him. It wasn't a published map. He could not have found out because of the contradiction. It was kept unseen. When he found out what about the statute, when he first got access to material. In
You
this
have
instance,
not been a note that they claim your client gave.
no, Your Honor, it was a handwritten note, and as far as I know, what they say in the affidavit, that's what she told me is reasonably accurate. Here's the book. I hope you enjoy it. Basically, that's it. There was nothing that was attempted to be descriptive other than that she said everything was her favorite character. That doesn't mean anything in terms of how Ms. Cooper might feel about that character. She had the book. She had not been to read it. There's no way in the law that she has been found to exercise any due diligence to find out about her rights to sue.
Counsel, this is a motion for summary judgment. In order to survive a motion for summary judgment, the plaintiff has to come forward with a party who is opposing. You provided the court an affidavit, and one has to do the damages, and the court say that's fine if we get past the issue of statute of limitation, which is crucial, because even if this court were to agree with the plaintiff on all arguments, the suit must have been timely filed. You make reference to a note and misrepresentation, but that was not affixed to the motion for summary judgment to create an issue in terms of a jury having evidence. Now, while you may keep that for trial strategy or for discovery reasons, it still would have had to be shown to the defendants. And certainly this court has to have the benefit of anything you claim to create a fact for jury deliberation. Without that, you have provided nothing to take this case case out of case law, even considering the discovery rule, that would provide the court the ability to take jurisdiction in a case where clearly on its face the statute of limitation had run. By affidavit your client had, for the information she needed to fall within the correct statute of limitation as early as January 9, without even giving the court a date. The next month, the book was published on February 10, 2009. An entire year transpired. And I believe your affidavit indicates that sometime during the summer of 2010, your client read the book. But that was after the statute of limitation had run. If you had told me she never got a copy of the book, that during the entire year the book was not published, the court could see you surviving. But I found nothing in your response or in the affidavits that would indicate that the statute of limitation did not begin to run until what I assume advanced is the summer of 2010. I found that she knew or should have known in January 2009 that the book was published, that it involved her, that there should have been something that a reasonable individual, either good or bad, would have got to read that book to determine whether it was good or bad. And without making any judgment, the court finds that the statute of limitation had indeed run on February the 10th, the year 2010, and that your suit is 1 year too late. Anything further, if you provide the court a copy of an order granting summary judgment in favor of the defendant on the grounds that the statute of limitation has run, and that there is no issue or matter for deliberation by this court or a jury.
Thank you.
Yes, sir.
Yeah, I want the negligence counts.
Beg pardon. As to the negligence, even though you made an attempt to say that there was fraud, that the court does not find that either in the complaint nor in any subsequent matter you advanced a legitimate statement of negligence of emotional distress under Mississippi law. You claim that, I presume, to gain the 3-year statute of limitation, but the court can't just look at the words in argument. I must find the basis for that when you're attempting to survive the motion for summary judgment, and you've not provided to the court anything that would survive, even to have that jury hear the issue of negligent infliction. You indicate that your client was told. You indicate there was misrepresentation before the publication. That's intentional. It's not negligent. And so as to the issue of the negligence, there is no statute of limitation that would grant you additional 3 years. So that's not ruling as to the issue, the fourth issue of negligence. Anything further, if you will email that to Ms. Ashley, the court will draft its own order in case you are out of line with what the court's ruling is. But I will make sure you send a copy to plaintiff's counsel. I will review it, make the adjustments as